So welcome back to Crack Grade B online learning platform. So in the previous lecture, we were discussing about industrial disputes. Now we will discuss about the machinery that is present in India to resolve industrial disputes. Okay. So here we will discuss about mediation, conciliation, voluntary arbitration, and adjudication. All these things we will discuss, and I will also tell you the hierarchical order in which these bodies function. And because you'll know the order, you'll be able to much better appreciate the concept that we will discuss today. Okay. So, what are the basic subparts within each machinery? So, the three main things are conciliation, arbitration, and adjudication. All these three things we've just touched upon in the previous lecture, but in this lecture we will go in depth. Conciliation involves conciliation officers, officers, and it also includes board of conciliation, okay. In arbitration we talked about voluntary arbitration, there is also a method that is known as court of inquiry. And then there comes adjudicating authorities, which includes labor courts, industrial tribunals, and national tribunal. Learn these authorities in the hierarchical order that I have just mentioned right now. When the conciliation officer couldn't resolve the dispute will be referred to board of conciliation. Okay. When the conciliation is not fruitful in resolving disputes, the conciliation officer can refer the dispute to voluntary arbitration. And if it is not resolved here also, then obviously the dispute will go to the highest adjudicating authorities, which includes labor courts, industrial tribunals, and as well as national tribunals. Understand? And this court of inquiry, we will understand that it is just a fact-finding machine, that it is used in order to inquire about some particular dispute and inquire about some provision or some incident about a particular dispute. Okay. And it doesn't give any binding award. Okay. So let's understand each and every aspect of resolution one by one. So first of all, we'll talk about conciliation. Okay. So I have already made a basic pictographical representation for what do we mean by conciliation. Let's understand this from here. So conciliation is a form of mediation. Remember this. These are key terms that you must remember. That conciliation is a form of mediation. And what do we mean by mediation? Mediation is an act of putting efforts to bring two parties, two conflicting parties, to a compromise. Okay. Making efforts to bring two parties that are conflicting with each other to a compromise. Okay. Compromise word you must have heard about in your college days, in your school days, when compro was very common. That two groups used to fight amongst each other and they engaged, some mediator used to come and make a compromise within those two groups. So it is more of like that only, but please do ensure that it is unofficial in nature, that it doesn't have a legal backing. So although the substance of conciliation is about mediation only, but the functions of conciliation have a legal backing. That means an act is there which tells about the functions of conciliation. What is the definition of conciliation? What does conciliation encompasses within it? So, what is the act which provides legal backing to conciliation? Industrial Disputes Act 1947. Okay, it says that conciliation is an act of providing a neutral party to resolve the disputes amongst disputing parties or amongst conflicting parties, and the aim is to reach out a mutually satisfactory agreement. Okay, this is the primary aim, not some award. The primary aim is to make both parties reach an agreement which is mutually satisfactory to both. Understand? So let's move on to the features of conciliation that I have already told you about. That conciliation includes conciliation officers and it also includes board of conciliation. Okay. Before going into that, let's understand that once the agreement have been reached where both parties have mutually agreed on, so the agreement will be binding on both parties for the period. What will be the period up to which it is binding? First of all, the primacy will be given to the agreement in which it is mentioned that for such amount of time period, this agreement will be valid. Suppose the agreement says for 1 year, we will follow whatever we have agreed upon. If that is not the case, then it will be for 6 months. Please do remember this, 6 months. Okay. First of all, the primacy will be given to the period of the agreement, and the second will be 6 months. Okay. And what will be the situation of rights, lockouts during the proceedings of conciliation? So the Act says no strike and no lockouts can occur while the proceedings of conciliation is going on. So during conciliation, no right, no lockouts. No right to strike, no right to lockout. Okay. Remember this, binding settlement and no right to strike and no lockouts. Why I am saying this? Because when we will study about arbitration, then these things will be reversed. And at that point of time, strike and lockouts can happen while the proceedings of arbitration is going on. Okay. So let's learn about conciliation officer as per the Act, which is Industrial Disputes Act. Okay. So the conciliation officer is appointed, since it is a statutory body, it is appointed by government. It can be either state government or it can be central government. Okay, so the appointment thing is very much clear, that it is appointed by government, whether the state government or the central government. So these government appoints a set of officers who have the power of a civil court. Okay, so that means they can call upon witnesses and various other powers that a civil court possesses. And the decision, as we have already discussed, it is binding on both parties. And for what time period? That we have already discussed. The primacy will be given to the time period mentioned in the agreement or the 6 months time period. Okay, and the procedure, the Act, since it is a very crucial disputes, not all disputes are similar, and we don't want to impose a top-down approach with respect to the resolution of disputes. So the government says, in order to be creative, the conciliation officers has to have a clear procedure, because that will reduce the creativity of resolving disputes. So that's why the Act, Industrial Disputes Act 47, do not mention about any specific procedure to be followed by conciliation officers. Okay. However, there is one limitation that is imposed on them, that they have to submit their report of resolution within 14 days. And this is given why? In order to expedite, that means to increase the speed of resolution of disputes. If we don't give any deadline to conciliation officers, the dispute can go on as is the case in judiciary. So this is a timeline in which a conciliation officer has to resolve the dispute. If he is unable to resolve the dispute within 14 days, or if he is unable to resolve dispute in any days, so the dispute will be referred to Board of Conciliation. So what is Board of Conciliation? Let's discuss about that also. So Board of Conciliation, it is a bigger body than conciliation officers. Its appointment is also similar to whatever conciliation officers, because it is also appointed by government, be it state or center. Okay. Another thing, what is the nature of this body? Nature, I mean that whether it is a permanent body or a temporary body. So it is a ad hoc body, which is temporary in nature. That it is only formed for resolution of dispute as and when it arises. Okay. These are the basic features that you must remember while doing any question, because these features will only help you distinguish between these concepts in the EPFO examination. Okay, so it is very essential to remember these things. So what is the membership under this Board of Conciliation? So it says that one independent chairperson will be there, plus 1 to 2 members each of workers or management equally. Okay, so it can be a possibility of a chairperson, one workers representative, one management representative. It can be a body of 3 members, or it can be a body of 5 members, where 2 members of management as well as workers are represented equally. Okay, so this is a crucial feature. Additional members will be added on the basis of equal proportion, not 1 member of management and 2 members of management, 2 members of workers will be there. Okay, so these are the things you must remember. The chairperson will be independent, and the representatives of management and workers will be provided here with equal footing. So we have discussed about membership also. Next is report submission. So the conciliation officers were given 14 days to submit their report. Board of Conciliation have been given 2 months to submit their report after the commencement of their proceedings of conciliation. Okay, within 2 months they have to submit the report to the government, that whether they have been successful or unsuccessful while doing the resolution of disputes. Okay, so the decision I've already told you that it is binding. Rights are similar to the conciliation officers, that these things are prohibited. Strikes and lockouts are prohibited. Whenever the proceeding of conciliation is going on. So you must remember these things. Here also these things are not allowed. So the major theme, we'll follow conciliation theme. So within this theme, at least these things are common. Appointment is common, decision is common, rights in common. Even the powers are common, which is based on civil code procedure. Okay. But the main distinguished feature between Board of Conciliation and conciliation officers is the submission timeline. For Board of Conciliation, it is 2 months. For conciliation officers, it is 14 days. Understand? So the Board of Conciliation is also done. So the basic features that are the important features we've understood with respect to the Board of Conciliation as well as conciliation officers. See, here also it talks about similar thing, that Industrial Disputes Act provides for conciliation. Can be utilized either through conciliation officers or by constituting Board of Conciliation. Okay. The time period is also mentioned, 14 days in case of conciliation officers and 2 months in case of Board of Conciliation. Remember these distinguished features, remember the overlapping features between the conciliation officers and Board of Conciliation. Okay. We've discussed about conciliation officers also, powers of a civil court. We've talked about that it doesn't prescribe any procedure. The report must be submitted within 14 days. And the enforcement period is 6 months only after when no such period is agreed upon during agreement. Next is Board of Conciliation. This is also we have discussed. Here it is 2 months. Now we will discuss about Court of Inquiry. Okay, so the Court of Inquiry is nothing but a basic methodology through which government seeks to understand the dispute much better. Suppose if there is a dispute going on in Gurgaon, so the central government located in Panchkula or Chandigarh, if they want to understand the dispute much better, they will appoint a Court of Inquiry. So they will appoint a Court of Inquiry which will gather all the facts, all the information with respect to that disputes, and they will submit their report to the government. Okay, so let's discuss about each and every aspect of Court of Inquiry. Here. So the appointment is by the government. Since all of these bodies are legally backed by statutory acts, so appointment is, their appointment procedure is also defined. This through state government or central government. This is similar to all the bodies that we have discussed. Next is, what is the purpose? So we are discussing what is the purpose of Court of Inquiry. This I have already told you, that if they want to inquire about any dispute, inquire about the facts of any disputes. So this is just a fact finding machinery. It will submit all the details by talking with the witnesses, by talking with the people that have been on the ground at that particular point of time, by talking with majority of stakeholders over there. The Court of Inquiry will bring a compilation of documents that includes all the details with respect to that dispute. That's why we say that it is a fact-finding machinery. In Court of Inquiry case, the report submission deadline is 6 months. Okay, remember these key differences, then only you will be much better appreciate these concepts. And here the rights Earlier by mistake I said voluntary arbitration. At that point during voluntary arbitration the rights were available, but that is not the case. The current thing is during court of inquiry the right to strike and lockouts are unaffected. Okay, and because it is not a judicial proceeding or a conciliation proceeding, so at that, so all these people are only available for informational aspect, so they can resort to strike or lockout while court of inquiry is going on. Okay, next is after their report submission to the government within 6 months, the government has to publish the report submitted by a court of inquiry within 30 days of receival. Within 30 days of receipt of the report published by court of, not published, given by court of inquiry to the government has to publish it within 30 days. Okay. So this is all about court of inquiry. You can read this in the content also, which is available over there. But majority aspects which are crucial for the examination, I have already covered in the understanding portion that we have discussed just now. Next is arbitration. Arbitration, we go for arbitration when all the conciliation proceedings doesn't give fruit to us. So all of these proceedings fail, and then the conciliation officer can persuade both the parties to go for voluntary arbitration. So the appointment of arbitrator is done by government, which is a common theme amongst all bodies. Okay, so the appointment of arbitrator is done by government, and this voluntary arbitration was not originally in the act. It was not present in the Industrial Disputes Act at 1947. However, at the amendment done during 1956, voluntary arbitration provision was put in the Industrial Disputes Act 1947. Okay, so the voluntary arbitration also has legal backing. Okay, please do remember this. These are the core aspects that can be asked in the examination. These are the core features that can be asked, whether voluntary arbitration has a statutory backing or not, whether Board of Conciliation or the conciliation officers have a statutory backing or not, and if they have backing, by which act they have backing. Okay, so you must remember all these aspects. Sorry. But here, there is a very crucial difference that you must remember. Source of power, as we all have understood. Give me 1 minute. Hello. Okay. So we were discussing about the source of power for arbitration. So in the case of Board of Conciliation as well as conciliation officers, we discussed that these two bodies has the power of civil court. So they had an adjudicating power, or you can say a power of a judiciary, but this doesn't have those powers. That means the source of its power of the arbitratory body is from the agreement by both parties. Whatever agreement both parties engage amongst themselves, that agreement provides the power for an arbitrator to resolve and give award to the dispute resolution. Okay. This also has to submit its report to the government and the enforceability about it. Let's discuss about this. 30-30 rule is there. Okay. That report submitted to the government, and after 30 days, within 30 days, the government has to publish it. Okay. And after the publication of the award given by the arbitrator, 30 days after 30 days after, the award will be enforceable. That means once the government publishes the award after 30 days, then onwards the award will be enforceable. Okay. So there is a bit of 60 days gap, 60 days maximum gap between the reach of agreement and not reach of agreement, but from the award given till the enforceability of that particular award. Okay. Once the arbitrator give award, it sends it report to the government. Within 30 days of receipt of that award, the government has to publish it, and after the publication of that award, and after 30 days after that, the enforceability of that award becomes applicable. Understood? And voluntary arbitration is preferred by various institutions because of its swift ability to deliver the resolution of dispute. If we go to the labor court and if we go to the judiciary or the tribunal, the time period in which the dispute can get resolved is very wide. It can go up to 3 years, it can go up to 5 years, but such disputes can't go that much amount, no? Because the production is hampered because of these disputes. So we want voluntary arbitration as a preferred method to resolve the disputes. And this is a perfect method, although the priority is to go for conciliation. But before going to the court, we should always use the method of voluntary arbitration because it is a very famous method, also used during Ahmedabad mill strike, which Mahatma Gandhi used it. Okay, so remember this also, and the benefits of voluntary arbitration. Okay, now let's go to the adjudication. Adjudication, it's like a judicial authority ready to give award to the disputes based on the interpretation of the laws or based on the interpretations of the agreement which the employer and employee engages in. Okay, so this adjudication includes 3 things. Let's understand each and everything. The adjudication, the parties approach these bodies, labor courts, industrial tribunals, and national tribunals, only when all the above options are used, utilized, and failed. Because all the above options couldn't provide them any dispute resolution, so they approached all these adjudicating authorities. Okay, so adjudication is done by either management or worker can approach these courts. This is a normal adjudication, but there is also one key aspect here, which is compulsory adjudication. What do we mean by compulsory adjudication? In compulsory adjudication, government refers the dispute to adjudicating authorities without the consent of these parties. Government says, we don't want your permission. We want this dispute to be resolved as soon as possible. So it is in our interest, it is in interest of the workers, it is in interest of the people. The government directly refers the dispute to the adjudicating authorities without taking consent of even the management or the workers. Or the government says the priority is dispute resolution, not your issues right now, not your interests right now. Okay, so this is what we call compulsory adjudication. So in adjudication, we have three types of bodies: labor courts, industrial tribunals, and national tribunals. These are hierarchical. That means this is the first level, second level, and the third level. All the levels are decided on the basis of amount of activities or amount of areas that these bodies cover. Okay, so the first level covers a limited amount of provisions, second covers a wide amount of provisions, and third is the national body, when there is a national aspect to the dispute. So national tribunal take into that. Okay, so let's understand each and every adjudicating authority and what are the key provisions of it. The first one is labor courts. In labor court, there is one chairperson or adjudicating officer, which is usually either ex or current serving High Court judge. Labor court is a one-person body, okay, which means that High Court judge or the adjudicating officer will see the dispute, will take into account all the aspects of it, will provide an award, which is a judgment with respect to what the dispute is going to be resolved like. Okay, and what does this labor courts have in its ambit? That in what provisions the labor court can adjudicate. So it is mentioned under, very important, please do remember here, this is very important, Schedule 2 of Industrial Disputes Act 47 mentions the various activities or various issues upon which the labor court can adjudicate. Schedule 2, one person adjudicating authority. So what are the provisions that are included in Schedule 2 upon which the labor court can adjudicate? Let's see them. First of all, see, labor court, one person only, who is normally a sitting or an ex-judge of a high court, and second schedule of the act mentions the issues which the labor court can adjudicate. So the first one is propriety or legality of an order passed by an employer under standing orders. If an employer passes an order, the labor court can check the legality of that. Okay. Next thing is application and interpretation of standing orders, that they can check the applicability aspect of it, discharge and dismissal of workmen and grant of relief to them. Since it's a judicial authority, the provision of providing relief to the workers is also under its ambit. Okay, withdrawal of any statutory concession or privilege, that it also can do. Illegality or otherwise of any strike or lockout. So the labor court can also check whether the strike or lockout is legal or illegal. Okay, and rest. Next is industrial tribunal. It is also a one-man body, similar to labor court that we have discussed, that it is the independent authority is there, which is usually an ex or current serving high court judge. So, and here the issues which the industrial tribunal can adjudicate comes under Schedule 3 of Industrial Disputes Act 1947. Very important, please do remember these things. It is mentioned here also, mentioned in the third schedule of the act. Okay, so why I'm saying this? Because the questions have been asked just like that based on the exact text that we have just right now studying in the class. We will see in the end also while doing PYQs that how these things are helping us. So let's understand what are the major issues that can be referred to industrial tribunal. Wages, compensatory allowances, hours of work, mostly related to economic things, leave, bonus, shift working. Shift are usually 6 to 5, 5 to 10, 5 to 12 and 12 to 6. Rule of discipline, rationalization, retrenchment I've already explained to you, layoffs and any other matter that may be prescribed. Okay. And there is one more difference in industrial tribunal with respect to the labor tribunal. Industrial tribunal, the chairperson can have 2 assistants with him, but that was not the case in the labor court. Okay, so remember this: Schedule 2, Schedule 3 and this assistant. These are the important features that distinguishes between these adjudicating authorities. Last but not the least, national tribunal. Above 2 bodies, that means labor court and industrial tribunal, can be appointed by the state government also. But national authority, national tribunal can only be appointed by the central government. No state government can appoint national tribunal or the members of national tribunal. Okay, so it says that central government may constitute a national tribunal for adjudication of disputes as mentioned in, and the ambit is also high. The second and third schedule issues comes under its ambit, and also any other matter not mentioned under these schedules can come under the ambit of national tribunal. Okay. Appointment of 2 assessors to assist the adjudicating officer is also there, the provision. Okay. And it has the power to modify or reject if it considers it necessary in the public interest. So this actually says that the award of the tribunal has to be submitted to the central government, and the central government says that it has the power to accept or reject the approval, the award in the interest of public. Okay. Let's move on to the key aspects, which says that unless declared otherwise by the appropriate government, every award shall come into force on the expiry of 30 days from the date of its publication. It is actually same which we were talking about voluntary arbitration. In voluntary arbitration, we talked about that 30 days. Within 30 days, the government has to publish it. And after that, after the publication, 30 days will be taken, will be after 30 days of publication and the award be enforceable. Same is the case in national tribunal also. Okay. So we have discussed all the adjudicating authorities, all the machinery which is used for resolution of disputes. Okay, let's have a brief look. We'll just talk about the common and distinguished features through a table so that we can easily remember what can be distinguished. So first of all, we'll talk about conciliation officers, board of conciliation, voluntary arbitration, and then labor courts, industrial tribunal, national tribunal. Okay. All these 5 bodies can be appointed by central and state government, but national tribunal can only be appointed by central government. Okay. Next thing is, it has been given 14 days to submit its report. Board of conciliation 2 months. Okay. And court of inquiry 6 months. Okay. Then in voluntary arbitration, 30 days for government to publish it. After 30 days after publication, it will be enforceable. Same case with national tribunal. Okay. These two are one person body. Ex or current high court judge. Okay. But in industrial tribunal, 2 assessors are given to assist the high court judge. Same case with national tribunal. Okay. These two have powers of civil court. This has its power from the agreement between employer and employee, and these are the adjudicating authorities, so power question doesn't arise. Okay, so these are the basic features that are important with respect to second schedule. So we are talking about second schedule in here and third schedule in industrial tribunal. So these are the common aspects. Now let's do the multiple choice questions in order to test our understanding. Okay. Since you've already done the previous lecture, please try to do the first question, which says, in which of the following strike cases the workmen after taking their seats refuse to do work by their combination? Please see the keyword seats, refuse to do work. These are the key strikes that I have explained to you. All of them have same meaning, that in sit down, workers sit down in the plant machinery so that neither the production can happen, neither the management can bring some people from outside and start the production. Okay, and they refuse to do work. So the answer is D. Let's move on to the next question, which is related to whatever we have discussed in this lecture. On failure of conciliation proceedings, the conciliation officer may persuade the parties to refer to the dispute to a voluntary arbitrator. What is true about voluntary arbitration? It has legal backing in India. Conciliation officer itself can do arbitration. Third party not involved in settling dispute. This is very wrong because voluntary arbitrator gets involved, which is a third party. Conciliation officer cannot do arbitration, and the voluntary arbitration do have legal backing under Industrial Disputes Act 56 amendment done in 1956. Okay, let's move on to the next question, which says what is not true about court of inquiry. Please see, the court of inquiry is required to submit its report within a period of 8 months. Did we talk about any body which talks about 8 months? So obviously this statement is wrong. We found our answer because it is 6 months. Okay, workers' right to strike will be suspended during the proceedings in a court to inquiry. This is also wrong. The answer is D. None of the above is true. Okay. Now let's do some previous year questions with respect to. So these questions were asked in 2017 EPFO. So the first question is, which one of the following is the process in which representatives of workmen and employer involved in an industrial dispute are brought together before a third person or a group of persons who facilitates through mediation to reach a mutually satisfactory agreement? See, I have given you the keywords. Please do give me the answer. Take a moment or two, otherwise I'll tell you the answer. This we haven't discussed, remove it. Because it is not about mutually satisfactory agreement. Arbitration also gives award, which doesn't, it is not an agreement, it is an award, it is a judgment on the dispute. So the answer is conciliation. Under conciliation, disputes are brought to before a third person, which is conciliation officer, or a group of persons, which is board of conciliation, which facilitate through mediation. We've initially talked about that conciliation is a form of mediation. Okay, so this is, please do check these keywords. If you don't follow these keywords, you can confuse between conciliation and arbitration because a third person is involved over there. And don't do these questions wrong. Whenever a question of this much magnitude comes, please read carefully, because then only you will be able, you can easily do such type of questions. Okay, next is questions relating to application or interpretation of a standing order under Industrial Employment Standing Orders Act may be referred to. Remember, standing order we've talked about, it was under Schedule 2, and which body got its ambit under through Schedule 2? See, because we have studied about these things, we could easily do these questions. Otherwise, if you go just randomly, you will not be able to, because all of the options are similar. Okay, so Labor Commissioner, no. No. Industrial Tribunal, Schedule 3. Okay, related to economic aspects, but standing order, Schedule 2, Labor Code. In this manner, you can easily do any question with respect to industrial disputes. So we have covered every aspect of industrial disputes. Anything which will come in the future, if I find any different question, I'll incorporate it in the future lectures. Okay, I wish you all the best, because this is a very important chapter. Please do repeat it once again in order to understand it better. Thank you so much.